Hello, my name is Mark DiCarlo. Tonight my guest is Mr. Terry Shamsie, a local attorney. I have you listed family law, juvenile law, criminal law, is that right?
That's pretty much it.
For quite a few years, and also a person who I have been accused of resembling sometime. And I don't know, I guess the size of our noses, Terry, I don't know.
I think I have the bigger nose.
That's what I tell people. He said he's skinnier and he has a bigger nose. I said, what's the score here? But, you know, I guess you're from up north originally?
Up north, Illinois.
Yeah, I'm from Ohio. Maybe that's
That's it.
Yeah, that's it. Some sort of ethnic kind of morass there we're involved in. So you've been involved lately in a local brouhaha that's gotten a lot of publicity, and I don't know when exactly the show's going to air. But, of course, it basically involved, in Kingsville, there's a district attorney, I think his name is John Hubert,
Right.
and John Hubert was allegedly covertly video and audio taping people in the hallway. And I guess that allegedly, and Renee Rodriguez, who's a local attorney, also is involved in this particular case. And allegedly, there was audio and video taping. A system was installed. And you're asserting that it's illegal or it was improper. Tell us why and whether or not my synopsis of the fact was correct.
Well, I think that there's several other lawyers now that have joined in the same thing. But basically, he installed a camera, and it catches audio as well. And it's installed immediately outside the 105th District Court room. So as soon as you leave the courtroom, you're on video and you're on audio. And that's generally the only real meeting place for lawyers to talk to their clients and whatnot. So a lot of times the judges will say, go outside, talk to your client, find out what he or she wants to do. And that's where we meet our clients, talk to witnesses and do
right. Well, and I could tell you specifically where I usually speak to my clients in Kingsville, Texas, is you go into that courtroom, there's like a bench that's catacord, or wooden bench. That's where I usually speak with my clients. Is that where the camera is?
The camera is, when you walk up the stairwell to get to
Yes.
the second floor,
Yes.
as soon as you walk up the stairwell, it's immediately above the door entering the courtroom. It's immediately above there.
Okay.
So the only area it catches, because he said he put it in for security purposes because he was concerned about the district attorney, attacks on the district attorney's office. It does not cover the stairwell. It does not cover the DA's office. It doesn't cover the entry to the DA's office. The only place it covers is where lawyers congregate with their clients.
Well, it would seem that that microphone would be pretty far then from where then anybody would be sitting, and it would seem like that it would not necessarily be very audible.
It's very audible. It's very simple.
How do you know that?
I've seen one of the tapes.
Interesting. So now it's my understanding, and I think you probably have researched the law on this. We have just video cameras in my office downstairs on the first floor, and there are to monitor people going in and out the front door and out the back door, and just to keep track of everything. But they're not audio; they're just video cameras.
That's correct.
And I thought I researched it, that if the cameras aren't visible, you have to say you're being recorded. And I thought that was a state statute. Is that right or wrong?
The person who puts it in has to be licensed by the state. This person was not, to our knowledge. The person also must put up basically a sign, right?
Right.
Disclosing the fact that you are being taped, right?
Excuse me. Mm-hmm.
And so that doesn't exist. So as far as I know, there's been no defense lawyers or their clients or any assistant district attorneys that ever knew about this audio taping for the last 4.5 years. No one had any knowledge. All the taping and the receiving of that information went directly to Hubert's office. It did not go to the sheriff's office or a third party for purposes of, security surveillance. It went directly to his office.
And I was speaking to another lawyer about it, and this lawyer had said that it's a violation of the Texas Civil Practice Remedies Code. Did you read that or
Yeah,
something?
it probably is. I've looked at, there's some civil liability, or probably anticipating some litigation there. I think there's criminal exposure, and there's definite professional standards. I mean, they probably he's violated at least 8 different sections of the professional standards.
The other thing, I don't know if you used to do this. At one time, we were told that the lawyers could record a conversation like an average person, as long as they knew they were recording it. But I think it was about either 10 to 15 years ago, maybe 15 years ago, I don't know if it was an attorney general's opinion, I don't know if it was a change in the rules of ethics. They basically said, no, an attorney cannot, it was indicated, we cannot record our phone conversations. And is that right? A lawyer can't do it, right?
Lawyers are not supposed to record, period, unless there's consent. So you have to have consent of all the parties and for a particular purpose, right?
Right.
If you think about it, we do depositions, there's recording, so you can record, but it's under certain circumstances and with certain consent. And absent consent and knowledge, it's deemed unprofessional, right, to do so. So if it's just a layperson can definitely
could record, right, on the phone,
without the other person knowing.
That's right.
Because they're not subject to the professional standards, they're not lawyers.
Right.
So it's a different sword that's basically used, a different standard. But his problem is enhanced because of the new laws that were passed and effective 2014, that any evidence or any recording you have, if you're the district attorney, you must turn it over immediately. So in every criminal case where he's recorded, regardless of what he believes the value of the recording is, he must notify the court, notify the defense attorney and the defendant that he has these available for their review, and he must preserve it.
Interesting. That's under what they call to be the Morton Act.
That's right.
That was surprisingly passed by a Republican legislature, which I thought was great.
Right.
And it's now it's made it much easier to practice criminal law because you will have all the evidence, pretty much. By the way, I shouldn't say this was gossip. I had a pretty big case over there in Kingsville, and I wound up getting a pretty fair offer, and I'm wondering if he didn't hear what we were saying. When we were saying, I said, hey, look, I don't know how he's going to prove his case because they can't prove that you had exclusive. So it may have worked for me in that. But generally speaking, well, what has Mr. Hubert, the district attorney in Kingsville, Texas, has he responded? Has he said, I didn't watch any of these videos, or these videos were not being saved on a hard drive or flash drive, or were they being saved, or has Mr. Hubert responded other than to say that it was for security?
Okay, so to answer all the questions, Mr. Hubert's position is that he got permission from a district judge to do it, but there's no evidence of that. His second position is it was for security purposes, but there's no evidence that it was ever used or anyone that really conducts security surveillance ever knew about it. His third position is, I gathered the information but never used it, and we know that that's not correct. And then the fourth position is that it is of no value to the defense anyway, because no one has a right to privacy outside, which is incorrect. And you can be in a public place and still have a right to privacy, especially when it goes to attorney-client situations. And basically it's eavesdropping. And he put himself in a real difficult position because by recording this stuff, he had knowledge of it, and by having knowledge of it, you have to turn it over to the court and to the defense lawyer. And for over 2 years now, he's went in himself or through his assistant district attorney and assured and signed off on sworn statements that everything, all the discovery you got, everything we have, you have.
So he's been signing off that the criminal defense attorney receives all the evidence on behalf of his client, and you're saying that was basically fraudulent.
Right.
But as I recall, there's no penalty under the Morton Act for the district attorney to fail to turn over all of the evidence.
But it invokes the Sixth and the Fourth Amendment, and under the case law on that, the judge can impose sanctions, or in extreme cases, dismiss an indictment. So you have to go to figure out what the motive was, what the harm is, and how do you remedy the harm. But in order to do that, you got to produce the information. And so therein lies the problem, the cost of production. How do you produce all those audio and videotapes to each criminal case?
Let's go backwards. The approval by the judge, the judge would have no authority to approve covert taping in a courthouse, right?
That's right. And so that defense doesn't work.
Okay.
And he's done it for a political reason, to try to spin it in a political view rather than he's the only one that knew about it.
And then the co-defendant, if you had a co-defendant that was making statements and he saw that, in other words, there were two persons charged in a conspiracy or whatever, that would definitely be something that the defense attorney would be entitled to,
Exactly.
Correct?
That's correct.
And what about the allegations that this is political, that Rene Rodriguez was involved with Angela Cabrera in getting her elected to that seat, and that he has and that Hubert was Mr. James Hubert, the district attorney in Claiborne County, is largely responsible for her removal because of ethics complaints that were filed against her, and that Mr. Rodriguez, who actually, I think all the attorneys in Corpus Christi, or at least maybe the ones with a member of the bar, I received a personal letter from Rene Rodriguez informing us of a lot of these fact situations. So, what are the well, is it true that it's political by Rene Rodriguez? You'll probably say no, but...
Right, well, no, because first of all that was kind of water under the bridge. The day before the revelation, I was in John's office talking to him about a different case, no animosity, and I did not find out about it until that case settled, and then the next day I only had one or two criminal cases left in Clayburgh, and that's when I found out about it. And so when I filed my motion, I went to talk to the DAs over there. I talked to Vincent Gonzalez. Vincent Gonzalez was the one that told me he had no knowledge of the recording. He said, Terry, I knew that there was a camera up there. I can't tell you who put it there. I can't tell you what it was gathering, and I can't respond because I have no knowledge of this.
Well, excuse me, did you tell me, are you willing to say, how did you find out there was a camera?
Well, how I found out was after I got done with this case I handled. That night is when I got calls from a couple of defense lawyers that told me, you weren't there the day before because I was out of town flying in to town. And they're the ones that told me the day before during the pretrial, he admitted in the courtroom that yes, there were recordings and they had recorded them. That's how it came to light. For the 4.5 years, I never knew. So once I knew that would affect my criminal cases. I knew it was a Michael Morton violation. I knew it was an ethical violation. And I knew that if true, he had a distinct advantage in every case because he had the ability to view the audio and video.
Well, certainly. I mean, it would be commensurate. What if I could see into the district attorney's office and see what they're saying about a case, even amongst other attorneys, right?
That's right.
Let alone with the victim.
That's right.
I mean, it would give me a big advantage. Actually, I kind of have a little bit of a war story. Some years ago, I got in a big fight on an insurance case, long-term disability case, and I told the attorney that I no longer wanted to speak to him by phone because I couldn't trust him. So everything was done by faxes and emails.
Right.
Well, then he made all these faxes going back and forth. He faxed me back the settlement offer and something that indicated that they'd done something illegal. So it helped my case a great deal. So this sort of thing goes, that's the sort of thing that goes on. I got that information from them.
Right.
Similarly, it's kind of like a spying thing. Why do we have, the British were famous for that, right?
That's right.
Spying and James
spying.
Bond, and you get the advantage intelligence. So in this little warlike situation, it would I would think give him substantial advantages. Well, don't worry about it if they don't offer. I mean, imagine we do this all the time. Yeah. Well, we'll just play chicken, and if he doesn't give us this plea, we'll do an open plea at the end.
That's right.
Or we'll try it before the judge. Maybe we can get a waiver. And he's hearing all this, right? Right? Assuming he is.
Well, the knowledge is impugned because I place it like this. If I gather the information and I need it, I can go to it. You never know it, right? If the case gets chancy and I need a little support, I can go to it, and you would never know. I went and looked at it, and then I found out today or yesterday, because the judge ordered for they give me certain dates, and the problem is I don't know every date I was there on this particular case. So the first 7 dates I gave them, they have emailed me and said, well, we can only retrieve 1 day and half of another day. We've been unable to retrieve the other days that you have requested, which is a problem because those are the days that we were there and talking about the case and witnesses were there. And so now they have a problem that they had evidence. The evidence has been destroyed and they're the only ones that preserved it, and we're supposed to keep it. So
let me say something practically though. I don't know that I would have went through everything that you're going through on the case, being older now. I don't know the facts of your case that instituted this whole thing, but I may have been more inclined to say, hey, look, I don't know, if it's relevant to this case, that's good. But you're just going to have to, look, stop this, or I'm going to bring it to the attention of the court. You couldn't have handled it another way than kind of going through this system and all these motions and the big media, causes celebre, whatever they call it,
The reason is because there's other critical cases I know I handled in the past over there, and that information, if he listened to it or had access to it, then that did affect my other cases. Well, that's number one. Number two is that once you take the step to gain the advantage, and I think we have an ethical duty to notify every client we've had over there to advise them, hey, if I handled a criminal case,
so now
you should have known.
So now I got to do that.
I'm just joking. I mean, I'm going to do it because
I don't do that much over. I don't need that much over there.
Because that kid that's sitting in prison or that kid that's on parole or on probation should know that, hey, you didn't have all the evidence in your case. It may or may not have affected your case, but you're still entitled to all that information because it undermines the integrity of the system. Why don't we be allowed to videotape everything in the DA's office and all their discussions and see how they feel, right? It's a distinct advantage, and you can't trust someone saying, well, I never used it, if they audio and videotaped it, and they lied for 4.5 years to every judge, every visiting judge, every judge that sat there, every defense lawyer, every civil lawyer, every defendant, and never disclosed it. That's the problem we're in. I didn't create the problem, he did, and his response is it's political. Well, it's not political if you have the data and you're the one that's sworn under oath time and time again that you gave all this data and information to the defense.
And how is, I got an email from Mr. Rene Rodriguez, who again I think was a supporter of Judge Angelica Barrera, who has since been sanctioned to such an extent that she had to make a promise with the Board of Judicial Conduct that she would never ever run for judge again. I never heard of such a thing, but whatever.
I think that how that came to light is that's how the video came to light. I think he sent the video, a copy of a video to them. And that's how everyone found out, wait a minute, we've been videotaped. So when he said, I never used it, right? Remember his first statement is, I never used it, never seen it. But that was not true. Because when they had me under oath in the court, they said, well, how do you know he ever used it? I said, well, I know one example for sure. And then after that, that's when they retracted their position and said, okay, well, we never used it in any of the criminal cases, right? And we agreed to suppress it and not to use it in your case and that you're handling right now. We will not use it in your case that you're trying right now. I said, well, that ain't the solution. The solution, you have to give me all the evidence.
And I didn't bring it, but the Texas Ethics Codes and the Texas Code of Professional Responsibility and all this, it's so vague that it's a little bit, you could be kind of scared that
Well,
everything you do could almost be interpreted as being a violation of those rules. So it's so vague and it's kind of scary. So you brought, what did you bring with you, Mr. Terry Shamsie?
I brought some because there's several.
Okay,
and
go ahead.
This is what a prosecutor's responsibility is, right? Along with all the other ones. Shall make timely disclosure of all evidence or information known by the prosecutor that tends to negate the guilt or mitigate the offense. That they shall not engage in conduct involving dishonesty, fraud, or deceit or misrepresentation. That would be to the court, right? The signing. Should not engage or should not conduct or engage in activity involving obstruction of justice, which would be not turning over all evidence known. Should not knowingly make a false or material misstatement of fact or law to a tribunal, to a court, which would be the Michael Morton right. Fail to disclose when necessary all facts to the defendant, right? Shall not engage in conduct intended to disrupt the proceedings. So if you're recording and not telling the court, you know you have engaged in conduct that immediately upon receiving the information, right, you have to turn it over to the court. And then the court is to advise the defense that says, hey, we got this information, you've been recorded, there's been conversation between you and your client. And once that occurs, then the defense has the right to, you suppress, not allow them to use a statement because it's a recorded statement, or to move to remove the prosecutor, right? So from my position, what I did said, well, it's not a problem. You recorded it. You're the only custodian. You're the only one you are now a witness in my case. And so I subpoenaed him for all the recordings.
Has anybody filed any ethics complaints
Yes.
against John Hubert, district attorney?
The answer is, as far as I know, yes. That's
Who?
true.
Do you know?
Several people, but a lot of that is confidential.
Well,
so.
the other thing, I will tell you this. I mean, I don't know. When I went over there, I never had a hard time with Mr. Hubert, and I think the last thing I had over there was a woman who was a kind of unusual middle-aged woman dealing meth or something, crystal meth, right?
Yeah.
And I found him pretty much to be, I thought, fair and above board. And Mr. Hubert is, of course, welcome to come on this show if he'd like to discuss this, if he can discuss it, either now or later. But I found him to be above board. But you know what I don't like, really, and I'm not saying this has occurred yet, but I just hate the gang up on the guy when he's Down syndrome. In other words, Mr. Hubert's down now, so let's take his license away. Let's file these complaints. Let's sue him. Let's even though it's hard for me to believe he did.
Well,
it's awful. It's awful to do this, but
Well, let's put it in perspective. If Mark Skirka would videotape outside the courtroom of all 8 district courts to gather that information, do you think that he would have a responsibility to advise the court and all the defense counsel that he's recording and getting audio out there? I think so. I don't think he would ever do something like that, number one. Number two is that Michael Morton Act was put into place to put a check on all district attorneys that you must comply with this. It isn't well, I know it might be difficult, but once you decide you're going to place these type of cameras, and the feed to the camera only goes to your personal office. Think about that. It only goes to you. So if you're not in the office 24/7, it's not providing the security you want, number one. And everyone knows it's the sheriff that provides security at the courthouse. That's the deal. So it's not logical. The defense isn't logical.
No, I agree with most of those statements, of course, or all of them.
And
the DA, I mean, the DA is not in charge of security at the courthouse. Plus, I have no indication that the Kingsville, the Clayburgh County DA's office had any threats or anything that you know of. Do you know of any?
Not that I know of.
Not that I know of.
I'm not privy to all that.
I mean, you have to use wisdom. Right. As a matter of fact, I think, other than there was a tragic shooting of somebody who used to practice down here, he was a county attorney.
He was up in the north
He went.
West.
He moved back.
Northeast Texas. He was by between Dallas and Tyler.
I knew that attorney. What was his name? McClelland?
McClellan. Mr.
Yeah.
McClellan. And his
I talked to
first
Mr.
assistant.
McClelland, and for those of you who don't
Mike
know,
McClelland.
there was a Mike McClelland that practiced law in this area, and I spoke to him right before he left, and he was going back. I think he was originally from up there. And then I don't know how many years later it was, I read about this tragic shooting that some person who was disgruntled, who had been was it a bailiff or something?
It was JP, I think, that he was
JP.
investigating for theft.
Right. And this JP and his wife goes and shoots the county attorney at his home, right?
He shot the first assistant, I think, Mike McClellan, in January 2013, and then in late March, I think March 30th, they went and executed Mike and his, I believe his wife too. They shot.
I think
both,
so.
right?
I think they shot them both. This was just a great tragedy.
And
They
those
didn't
were
get a
done,
lot
I
of
think, at the
coverage.
house, right?
I think at
That-
his house.
I think so, because I think the first assistant was shot right outside or in back of the courthouse when he was walking from his car.
Well,
to
didn't
the
you
courthouse.
I think he told me he
practiced-
practiced with
Yeah,
you for a
no,
while.
I knew him. Real nice guy.
He was
Real good
yeah.
guy. I mean, level-headed.
Yeah.
I mean, so
Well,
that was a shocker. So.
My phone's going off here in the.
Okay.
Sorry about that. But yeah, that was a shocker.
Yeah.
So it could happen that you are susceptible to some sort of danger. I mean, it's not unknown, but you and I don't know of anything specific that happened in Clayburgh County that would precipitate that. And in fact, I guess your position would be, and I would agree, if in fact there was something, then they could take security measures. Now, there's pretty tight security measures in many courthouses, in Nueces County, for example. I don't know there was in Clayburgh County, but that would have been, I guess, a job for him to go before the county commissioners, right? And to ask
Yeah,
for...
I think that's what happened, that he didn't do it. I think that the district judge did, and then they went to Austin
Mhm.
and testified there, and then Austin gave them a grant, and the grant went straight to the sheriff's department to install security, whatever
Mhm.
was necessary for the courthouse. So the sheriff was already doing that, taking care of those measures. So
Who paid for this camera?
that came out of his funds.
The drug fund.
That's my understanding.
Talk about the drug forfeiture fund. That's where in the district attorney of these various towns are able to use the money for the drug forfeiture money or vehicle forfeiture money. They'll forfeit cash
jewelry
that's
or
found in
whatever.
vehicles that's used to transport drugs or to possess drugs, or vehicles to transport or possess drugs, and then they sell them. So they a lot of times have this big slush fund of money,
So,
and it was in fact abused, allegedly, I think it was confirmed, in Alice, Texas, also known as Jim Wells, where the DA got in similar trouble for using money from the drug funds for, I think it was for bonuses for his staff,
yeah,
correct?
I forget exactly what it was, but there was, it was kind of over a period of time, and I'm not
That's-
sure the exact detail, but I know there was an allegation, and I think that resulted in a resignation or didn't
I
run
think
again or something.
well,
like that.
no, it resulted. He went to prison for that.
Okay, see,
Now for a brief
didn't
period
know.
of time.
Okay.
Well, I practiced over there in Jim Wells, and he did go. Joe Frank Garza, right? Wasn't that his name? Joe Frank Garza, I believe was his name.
I don't know.
Okay. Well, he did go to prison, and I kind of knew him. I felt bad about that, and I thought, well, I didn't think the evidence indicated that he was using it for himself. I think it was for bonuses for his staff, which he
Secretary
may
or
have,
something.
he felt was underpaid.
Underpaid.
But it does bring up an interesting issue. If we know that it happened in Jim Wells, forfeiture money was allegedly misused, and we knew it happened arguably in Clayburgh County, maybe somebody better look into all this money that they're getting.
Well, I think there
And
are
how it's being
audits,
used.
There are audits done, but the problem is that the audits sometimes can be vague. Some of the invoices I saw just said cameras, so it doesn't say like security courthouse installation camera, right? It just says camera, right? Purchase, and then because it doesn't come out of the general fund or the fund that the commissioners handle, it's the drug forfeiture fund, they generally sign off on it without any real knowledge of what the situation is. And so that's the gentleman who got the no bid contract to install it, and he's the one that I had on the stand, and he's the one that took the Fifth Amendment for about 30 minutes about the installation, the bidding, the rigging.
How much was he paid?
I believe at that time for the camera was $2,000. He had made about $40,000 to $50,000 per year. He ran a private company, but he also works for the adult probation department. So he's a full-time employee there, but did contract work for the county on the side, different departments or elected officials. So because of taking the Fifth, a lot of the information, right, that would be valuable for the public to know, you can't get.
Okay, what is the name of the man who was on the witness stand that installed these cameras?
Well, the one that is Brian Birdwell.
So Brian Birdwell was on the stand in a criminal case that you were involved with, and you asked him, you wanted to know, have some sort of pretrial hearing on a criminal case you were involved with, and you were asking him questions. Did he answer any of the questions, or did he take the Fifth Amendment stating that that anything that he says can and might be used to incriminate him for
He answered
criminal
general
allegations?
questions like, his education, his name, what I call the general, just informative questions. Once it got to the camera or the installation or the bidding or anything like that, all Fifth Amendment. Took the Fifth on everything.
Okay, so the thing is I don't think are you free to share the name of the case, or would you rather not name?
I'd rather not name
the case. What the kind of case that's pending that you are representing someone for? What is the nature of the case? I believe it's an assault case, isn't it?
It's assault, aggravated assault with deadly weapon, first degree felony, alleged family violence. So it's the game you're playing for is 5 to 99 years. So I mean, we're playing for all the marbles.
Well, you are, but nonetheless, merely because let's assume that Mr. Hubert acted incorrectly, which, I mean, it appears to me, by what my knowledge, that he would appear to have acted very incorrectly. But it's not necessarily going to win your case for you, because the other evidence still exists.
Well, I don't agree with that. Because the case is very, very complicated.
Okay.
It's not a simple case, and so...
But let's say just for the sake of simplicity, then maybe not in your case, but in many cases, I mean, if you got that confession and you got the Miranda rights, the Miranda rights are usually written on the confession. Of course, they've changed it now. Yeah. Now it's oral, right? You got to watch all these videos now, right? So we're watching this video, and you got the Miranda, and this person confessed to it. Well, whether or not Mr. Hubert acted improperly, or whatever. You got that confession, and it's hard to get around it. So,
first, I don't have a confession. I don't have a confession. Second, I have Sixth Amendment violations, and I have a pattern and a practice. And Sixth Amendment violations and pattern and practice, and a search, Fourth Amendment violation, pattern and practice, can invoke other remedies that can greatly affect an outcome of a trial, or even the possibility of a trial.
Well, let's assume that did you file a motion to recuse or remove Mr. Hubert from prosecuting the case, the DA's office?
He recused himself.
So he recused himself, and did they appoint I believe they appointed a special prosecutor in the case, right?
Yeah.
So he can just go on the evidence that he has. Are you saying that he would be contaminated because of this evidence that they incorrectly procured?
He inherits what they gave him.
Well, right? Maybe they should say the judge should have ordered. I'm not saying what the judge should have done, but don't give him that.
Don't give me that.
Well, don't give the judge who signed for the recusal. Let's say, don't give the new prosecutor this covert video audio tape.
But that's what was done.
Okay, that sounds
right. That's
like a plan.
Was done. Right. But the problem is that he's got to produce it, and if he can't produce it, then he's got a problem. Right.
Right.
Because in order to sign off on a Michael Morton, before you can start a trial, you got to sign Mike Morton. I give you everything I've got. All the evidence is there. because then you get jury instructions and you get other issues about the destruction of evidence and why it's destroyed and who the other witnesses are. So it becomes very, very complicated.
And Mr. Bryan, now, have you researched criminal prosecution for either Mr. Brian Birdwell or for Jim Hubert regarding what actual violations of the Texas Penal Code may or may not have occurred?
The problem is that you don't have all the facts in the box yet, right?
Right.
You don't have, so, everything is just speculation. You don't know because until the case develops a little bit further, and until there's more testimony, I think that it will narrowing down. But I think that you cannot, and you have no right to eavesdrop on private conversations. And
it's a county facility. I mean, it's not like it's outside. It's not like it's in your property. It's a county facility. Well,
I mean, the case law is pretty clear. If you have an expectation, a reasonable expectation of privacy, right?
Mm-hmm.
So if you talk to your client outside and you're talking to them, just because you're in the public domain does not mean that you don't have an expectation of privacy. Otherwise, every time you're talking on a mobile phone, right, and if no one's around you, you get away. If they leave a mic to record you while you're talking on your mobile phone, right, which we know what us lawyers do outside the courtroom, right?
Yes.
Then they're intercepting attorney-client. And it may not be on that client, it could be on a different client. Because when we go to the courthouse, we just don't talk about one case, right? We're dealing with 10 to 15 cases.
I tell you one thing I would be very afraid of. I don't know if you do much federal work now, but
I do some. But
they got a lot of money. They got a lot of power.
Yeah, they do.
And I would hate to ever run astray of doing anything in violation of federal law. And I do know that some of those checkpoint cases and that are the ones the feds refuse are turned over to that
agency.
Kingsville. So I don't know if there's a federal overlap or not, or if the U.S. attorneys are going to look at it. I would say this. I would feel sorry for Mr. Hubert in this respect. I mean, by outward appearances, a little bit I know. He went through law school. He has a degree, and I never had any. I didn't know of any issues regarding him, and it would seem like this was a very drastic mistake, assuming that everything we're saying is true in terms of hurting him professionally and personally.
I don't agree with that. I don't agree with that because you are that well educated, because you are that smart. And if he was out for a year or 2 years, we give like the junior lawyers a break because, they're junior lawyers. And so you kind of give them the pass because they probably didn't know any better. They might have crossed the edge, but, you're okay, you crossed the line, but, I don't think you understood all the implications. But if you've been out for 10 years plus, And when you plant something to record audio, This isn't something that was just done by a whim. This was done in secret. This was not brought to the commissioner's attention. It was not brought to any other assistant district attorneys. It was not brought to any defendants, defense lawyers, no visiting judges, nada. Just him, and it was wired just to his office. And it was a continued feed for 4.5 years. So you cannot justify the capture of all that data and then claim, well, I'm ignorant. I didn't realize it. No, you realized it, and we know you utilized it. And now to say, well, no harm, no foul, believe me, I never used it, I'm not buying on that theory. I'm not going to bite off that theory.
I was just speaking conceptually that, of course, I do criminal defense, and a lot of people think we're awful, that the people that do it. And some of the worst cases, it's easy to condemn people, but when you have to look at their side of the case and you have to advocate for them, it's harder to be merciless. And I just hate to see, I'm disagreeing, I guess, we're the only disagreement we've had so far. I just hate to see somebody throw their career away on something so stupid.
Well,
which he very well may have done.
Well, let's think about it, because this isn't the first time this has happened, right? We know that Nixon secretly recorded tapes in the White House.
Let me tell you something.
But
let me tell you something about that deal. Those were all. So did Kennedy. They all did.
That's right.
They only brought it out about Nixon.
I agree. But
And,
here's the deal.
and that was. Let me tell you something about that deal too. I'm no Nixon fan by any means. That was all pretty questionable with Deep Throat. He was a CIA involvement. That was all pretty. I'm not saying Nixon should have done it, but that's like they latched onto that. You could hear those LBJ tapes right now in the
I
LBJ
agree.
library.
Here's the deal, though. We know that the focus of the production of those tapes centered around the break-in, right? And the issue
that's
was,
an intelligible
did you or did
issue,
you not
yes.
have knowledge of it, right? That was the issue. So the evidence was
Well,
very
that's
important.
that's correct.
Right?
This is correct.
That evidence is very important. The production of that evidence and the timely production and what it contained. That's the deal. So in this one, when you have a criminal that's facing life or you have a criminal that's facing any kind of jail time, every piece of evidence that you know about, you have to produce. You don't get the push that says, well, I don't think it's relevant. Or remember his first defense is, you had no right to privacy. That was the defense, so I can record you. That was the defense.
Well,
right? That's the defense.
you got to watch what you say on
Yeah.
these things. You know.
So
he should have.
he should have consulted a lawyer.
Yeah, he should have looked at it
should have
for a
talked to a
lawyer. I
lawyer.
don't know. You know.
That's right.
You want to dig a hole for yourself. You know.
That's right.
So right.
So I don't agree with that, and I think that if it would be you or I that recorded any other individual in the courthouse
Yeah.
and done so that long, I don't think we would be
Well-
sitting in the position of giving us a pass. I think they would be very, very difficult on us.
And I'll agree with I'll agree in this respect also. How many guys right now during that period of time got like life over there?
That's right.
And you would think, I don't know if there was a capital punishment wherein the death sentence was given, but you would think that would definitely be out the window if that was done. And these bigger sentences, which I guess I'm cavalier because I haven't lost one of my clients over there to big time lately. I haven't had a big case where the big time. I had a big case over there, but we worked at, whatever, it worked favorably for me, for my client. But if I'd have a guy right now serving life, I'd say, hey, no way. Especially, every once in a while you get a case that hurts you, right?
Right.
You say, man, this guy, it's his first time.
Right.
And the proof was a little bit questionable because it was child molestation. He got this big sentence. I feel terrible, man. Right?
Yeah.
Happens to us all that are
That's
doing
right.
it. Then I think I would be up in arms.
See, I think of it this way: if one person spent 1 hour more or 1 day more than they should have in jail, that's good enough for me. You got the advantage because we're supposed to be held at a higher standard. Right, we're supposed to be the intellectuals, say everybody's playing fair ball, and for that person who generally is not very well versed in the law to be cheated out of a day of their freedom or a minute of their freedom, to me, you cheated. And if the sentence should have been 2 years probation, but they got 4 because you got inside information, or that you're listening, or you're seeing our conduct outside, or you're hearing our conversations, you cheated. So that person has suffered harm, and the only way you know is do a forensic evaluation of all the evidence.
Who's going to pay Who's going to pay for all that money? That's
The
going to
one
cost a
that's
fortune.
the custodian of record has to on each and every
Maybe
case.
there's a lot of money in the drug fund over there. They could do
There
that.
ain't gonna be enough because just on my case, I think a complete review is estimated between $90,000 to $120,000 because you got to go through all 2 years of taping to figure out when I was there and who I talked to and under what circumstances.
You would think there'd be a way, though, it might be cheaper just to go through everything
Can't
and then
because-
send it out. No?
You can't because you have to isolate each lawyer, each conversation, each case. I mean, think about it, right? There's 2,000 cases, and you recorded every
Well,
one.
I
and
do know-
each
I do
lawyer-
know-
Now the lawyers are requesting it, right? They're saying, "I want the
Yeah.
production."
Yeah, if you've had any, that's interesting and it's true because if you've had any experience in trying to find something in a video, even if you know where it is, it's still, you've got to spend the time to look for it and isolate it. And then there's different, sometimes I don't know, assuming that the time and date wasn't
Right.
off. If the time and date was off, geez, it'd be a real nightmare.
And then if like what I've been advised that some of the data isn't there, well, then the hard drive has to be sent to a lab, FBI lab, a DPS lab, to go back and recreate if you can. that video and those dates. And if you can't, when was it destroyed and under what circumstances?
The case that initiated all this was you're court appointed over there, correct? Was it a court appointment?
No, the case that initiated all this was a forfeiture case. And because of that forfeiture case is how I found out that it happened in my case. I'm retained on this one, but because of all the expense, because we had all our experts and ready to go to trial this coming Monday. Special setting, preferential
On the forfeiture case or the criminal case?
On the criminal case, we're specially
Okay.
set. But with all this development in the last 30 days, they can't comply with the discovery, and now all the experts are off in my case, and so it looks like now it's going to be a long time before they're ready.
And the criminal case was originally a court appointment, is that correct?
No, it was a retained.
It was a retained case?
So that's why I filed my motion to be appointed based upon violation of Sixth Amendment rights.
What's the Sixth Amendment? I forgot.
You have a right to counsel of choice. And so what happened was, by their conduct, they drastically increased the cost of the defense. And under the contract, if anything unusual comes up, right, you got to pay additional money. The lady said, I can't pay any more money. We're broke, we don't have no money. And so the move is, well, the state said, well, she can be appointed counsel. I said, she sure can, but if you do that, you violated attorney of choice under the Sixth Amendment. So you can't benefit from that. The state has to pay my fees now.
Mm-hmm.
Right? Otherwise, you have a Sixth Amendment violation.
And so what is it that you want
I want all
on
the
this
evidence.
case?
I want all the evidence. I think
Okay.
it's important, and I need a compliance with it. I don't know if they're going to be able to do it.
So let's assume that the Morton Act probably says something like all the evidence that you have. What if they don't have it? Maybe are they technically in compliance then?
No, because they got to give an explanation, and then I get to call the people to the stand, the DA and his whole office, as to the existence or non-existence of recordings and what happened to it, and I get a special instruction.
And a special
If they can
instruction, you mean that the jury gets to read this statement stating that whatever you should consider any evidence that wasn't,
If it gets that far, then you got a violation of the Sixth Amendment. You also got a violation of preservation of exculpatory evidence, and so that can greatly affect the case, and if it can even get to a trial, right? You don't get to choose. You don't get to destroy the evidence you don't like. And if it's in your hands and you should have preserved it and you were secret, think about this. If you're with your client or you're with the witness and they don't know they're being recorded and you tell them something, right? And you're the client and you tell them, I didn't do this, and you explain it to him, right? Your lawyer. Then that is preserved and recorded by the DA's office, and then later not retrievable or destroyed, right? Well, that evidence is exculpatory, right? Because it says I didn't do it.
Mm-hmm.
And it's not self-serving because you didn't know they were recording you, right?
Mm-hmm.
So that in effect is exculpatory evidence that now puts you in a position, the only way you can get the evidence back is for her to take the stand and waive her right to the Fifth Amendment, right? Or to find a remedy for the intentional destruction of exculpatory evidence. Right? And the truth is, generally, when clients talk to their lawyers, is very truthful disposition as to what happened, right? And so that is
not with me always. I
Okay.
say, hey, look. I say, look.
Okay.
Wait a minute.
Okay,
I'll say
that
stop.
might
I'll
be
say
true,
stop.
too.
I'll say stop.
Tell me the truth.
Stop. Don't tell me anything else. You just answer my questions. I don't want to hear anything else.
Okay, so
You've probably been in that position, right?
I have, but I always, I always tell them, look, give me the whole thing. Give me the whole thing.
I don't know.
And the reason is because I want to know if I'm going to have problems later, right? And generally, it's in these kind of cases that I'm dealing with, it's something that is high detailed. So I do take a lot of notes. I have them tell me the story 5 or 6 times to make sure I've got it in my head.
You seem to have some knowledge off the top of your head about the amendments and the Constitution, et cetera, which my rote memory isn't the greatest. Are you licensed in the Supreme Court? You been up there?
No, I haven't. No,
Yeah.
There's very little relief there. Right? Most of it is done.
Well,
trial work, right?
talking gossip.
Yeah.
I've been licensed for a while up there, and I had a couple cases up there. But I was, I don't know, did you practice you were in Houston for a while, right?
No, I was in Tyler, Texas.
Oh, okay. I went to law school in Houston and all. Anyway, there were lawyers that, they were always pretty much the same. They did constitutional law, and they were like usually in a big house or something by themselves. Yeah. They didn't have any secretaries, and that's all they did. Yeah. And I had a case up there in the United States Supreme Court, and one of those guys, I got the impression that's the way he was. He just did constitutional law by himself, had one or two cases at a time, and we were discussing it. One thing that I was very disconcerted with in talking to this lawyer that just did constitutional law at the United States Supreme Court, of course, he said, he called me up because I can't remember the whole procedure, Terry, but he said the way it was that, I can't even remember if you file a writ up there or what it's called, but he said they must be looking at it very carefully. He said, congratulations for them doing that. He said, you may get hurt or something. But what he told me, and this is something I found disconcerting, he said there's only certain kind of cases. You could kind of tell what kind of cases the United States Supreme Court's going to hear. And he said, like a lot of the ACLU cases have preference. And I was a little bit...
Wow.
I was a little bit shocked by that, if that's true. And I think it is in my whatever impression of cases the last 30 years since I've been practicing. I think it's true. And I kind of think that's bad if the American Civil Liberties Union has an inside in having inside track in having their cases heard. Where in a person like mine, and again, I'm no great, that was actually a civil case that was brought up by a salesman that was on campus, I believe it was at the University of Houston, that was held up for a discommensurate period of time for failure to provide his Social Security number, right?
Right.
And he'd have the money to fund a case like that. But that was a little bit dissettling. But it sounds like your case, with your knowledge of the constitutional laws and all this, I mean, you could get licensed up there. Maybe you'll bring it that far. I don't know.
Well, I'm a trial lawyer, right? So I try to find the success at the trial level.
Well, we need to.
It's so expensive
why is it?
to go up.
Why is it? We were talking before the show about why you try to win at the trial level.
Because you don't get any relief upstairs. Once it leaves the trial court,
the chances of winning a criminal case that you've lost at trial for a criminal defendant in the Corpus Christi Court of Appeals, or it's not called the court. It's not 13th Court of Appeals.
Or going up to
winning the 13th Court of Appeals are very minimal, right?
Very, very minimal.
Why do you think that is? Do you want to say, or are you going to get political hot water by saying that?
Well, no, I think that the president is, it's all the case law is basically against the defense, and has been built up in the last 30, 40 years that it is nearly impossible to get any relief.
Mm-hmm. So if you lose a criminal case at trial, your chances of winning on an appeal are almost non-existent.
Maybe 3 to 5% at best.
Mm-hmm.
Which,
and do you think
so minimal?
And you think it's because the case law is built up against
case law and if you even if you went at the 13th court, you go to the Court of Criminal Appeals, and they get to hear all the district's appeals. That is so weighted against the defense that it's almost impossible to win.
And have you personally seen cases, or have you tried cases that had good appealable issues that you think that the 13th Court of Appeals acted in an egregious manner in not reversing them? Or
the one that sticks out in my mind, and I don't think it was to the 13th Court, because I'm thinking it was out of Brownsville. I think that's where we tried it, probably 15 years ago, where it's a capital murder case, right? So they're seeking death, and they have co-defendants. So the co-defendant, that young man, his lawyer fell asleep during the trial, right? Fell asleep. That would be pretty...
The co-defendant's lawyer.
Lawyer.
In other words, there were two men on trial for capital murder,
right,
and you were representing one, and there was another lawyer representing the other one, and he fell asleep.
He fell asleep. So we were representing the lady. The other lawyer was representing the male.
He was tired. We get tired.
And he fell asleep, but he fell asleep in critical issues, right? Critical.
I'm just kidding.
So
I had a judge do that.
Well, they took it up on appeal, and they said, well, basically you didn't prove when he was sleeping, right? But
Right.
how does a young guy that knows nothing about
Well,
the
see,
criminal
they'll always
justice
come up
system
with,
know?
see, they'll say that.
Yeah,
They'll say that. Well, you didn't prove when he was sleeping. But then if you proved when he was sleeping,
They say, well,
they'd
no
say
harm.
something else.
Yeah, there's no harm.
In other
no
words,
foul.
right. So in other words, it's
Yeah,
when people, I hate to say this because this sounds so subversive, but when people talk to me about the law and all, I sometimes, I tell them, do you think it was when the United States Supreme Court said to quit counting votes in the Bush-Gore election? Do you think that was the law?
yeah, I know.
I mean, people have a great respect for the law, etc. And the United States Supreme Court says this and that. And I'm thinking to myself, as being an insider for many years, well, maybe that's good that there's this persona
Right.
of officiality and respect, and this is the law and honor and all that. But I wonder.
I don't think the normal person believes that anymore. I don't think they.
I don't know.
I don't. I think they understand that the system
And-
is based on money,
Mhm.
a large majority of it, and they see the system
Well,
and it's very
Mhm.
difficult for them to. They want to believe that people get a fair
Mhm.
shot, but in the honest, once you put them in the box, the jury.
Well,
Vordire picking the
and-
jury, and you ask them, does a rich man get the same justice as a poor man? And they're going to tell you no. There is two different systems, and that is
I'd
very
object.
troubling.
if you ask that,
Well, I
defense
ask it all the time.
and,
Do you
you
think
probably
a
get an
public-
objection. But
No, I never get an objection.
well,
Because I think it's relevant, because I represent this person.
at any rate,
you know,
well, and I'm going to say something so people don't think that I'm on one side of the fence on this issue, and you probably disagree. Do I think the Supreme Court had the right to overrule the laws regarding marriages in the state and say, oh, okay, homosexual marriage in every state in the union, all your rules are overruled? No, I don't think they have the legal right to do that, and you may disagree with that. So I want it to be clear that I'm not just taking an advocate for a political
Right.
position, that I have a general, unfortunately, cynicism sometimes for the way laws are written. I read a decision by Judge Scalia one time. He didn't cite one law. I said, well, where's the law? Where's the you just say what you think? Well, this young man was a role model. Because he was a role model, you had the right to search his locker? What kind of a judicial opinion is that? So that's my cynical, and I probably spoke too much, as I do sometimes when I have a lawyer that's a guest like yourself. Mr. Terry Shamsie, thank you for coming
thank you for having
on,
me.
man. Family law, juvenile law, and criminal law, talking a little bit about this Clayburgh County scandals and issues regarding covert taping. Thank you.
Thank you
Terry.
very much.
Bye-bye.
I appreciate it, Mark.
Good night.